My Lords, it's right that we approach this debate with seriousness and once more the responsibility to ensure real scrutiny of the bill rests with our House. Today, the Government is attempting to rectify what the UK Supreme Court has identified as serious and systemic defects in Rwanda's framework and procedures for processing asylum claims. Its past and continuing practice of refoulement and the changes in procedure, understanding and culture needed before Rwanda can be considered a safe third country. However, the bill as it stands risks entangling us in a complex web of ethical and legal dilemmas that could diminish our international reputation, betray our duty to the genuine asylum seekers, undermine the rule of law and place our courts in an exceedingly difficult position. It risks creating a legislative or legal fiction. Much has been said about the infamous late-night pyjama injunctions or Rule 39 orders and the meddling of the so-called foreign courts. Let's be clear, my Lords, the European Court of Human Rights is not a foreign court. It is a shared court. The UK was instrumental in its establishment and has significantly contributed to its jurisprudence. A British judge sits on the court and British lawyers are involved in its administration. In Rule 39 orders against the UK, the context is that the court grants only 2% of requests. Last year, there was just one. Also, last year, the court found the UK in violation of the ECHR on only one occasion, the 38th lowest of all member states. Under this bill, ministers will have the power to ignore Rule 39 orders. Neither these new powers nor any amendments to the Civil Service Code would alter our international legal obligations. Should a minister opt to disregard interim measures, this would place the UK in direct violation of its treaty obligations. My Lords, how can the UK continue to be a global advocate for the rule of law, as many others have said, and honouring international commitments if this happens? To illustrate the unprecedented nature of such an action, no member of the Council of Europe has ever taken steps to disregard ECHR rulings or interim measures, except Russia, and that's not good company to be in. I'm not alone in being perplexed by the inconsistencies this policy and this bill will introduce. Our treaty with them obliges Rwanda to adhere to the Refugee Convention, yet the bill explicitly exempts the Refugee Convention and other international obligations from consideration within the UK. My Lords, the government may not thank me for doing so, but I feel compelled to remind the House of the agreement with Rwanda, which included an intent to resettle a portion of Rwanda's most vulnerable refugees here in the UK, a process that, as we know, is already underway with numbers increasing. Even if the plan is enacted and we will finally have refugees going to Rwanda, the numbers will be modest, in the hundreds at most. By comparison, in 2023, almost 30,000 irregular migrants entered the UK via small boats. Even so, my Lords, it's perfectly fair to ask those of us who dislike these provisions, how are we going to deal with the rest? My Lords, there are many tools available to the government. We simply need to know which tools to use and how to deploy them better. And the government has actually made progress, and I would like to commend them for that. Small boats crossing, as my noble friend the Minister has said, are down by 36% compared to 2022. The grant rate for asylum decisions in 2023 was 67%, down 9% on the year before. But when I was Immigration Minister myself, it was actually 19%, applying the criteria of the 1951 Refugee Convention fairly but firmly. And to clear the backlog, the number of staff working on asylum cases has indeed increased significantly, and 112,000 asylum cases were processed in 2023, the most in any year since 2002. The government has signed an agreement with Albania for removal of their nationals and to strengthen cooperation. To date, 5,500 Albanian migrants have been returned. The deal with France last year has greatly enhanced cooperation between our countries, and further agreements were secured correctly with Bulgaria, Turkey, Italy and Georgia. All of these tools and a number of others have been and will continue to be more effective, my Lords, in stopping those boats than these Rwanda proposals. The government should focus on these instead and I believe the country will be grateful. My remarks today, my Lord, stem from a deep sense of regret and disappointment in witnessing how we have become embroiled in what can only be described as an unhealthy obsession with Rwanda. This fixation appears to be an attempt to satisfy certain factions and certain individuals who seem to possess neither the depth of understanding nor the nuanced appreciation of the complexities involved in asylum and immigration matters. For them, my lords, nothing will be enough, neither this bill nor ever more radical ideas. If we are to restore the public confidence in our ability to manage our borders, we should focus on the other tools available and, my lords, avoid the inevitable problems which will ensue, most certainly will ensue, if we persist with these proposals.